how do you personally look at a law and decide whether it's just or not? Pretty basic.
Well, Senator, that is not the role of a judge to determine if a law is...
No, but it's the role of a human being. I'm just trying to get to know you. Do you have a personal definition of justice?
Well, Senator, justice, in my particular case...
I know it's applied equally, but how do we know a law is just or unjust, in your opinion?
Can we just, I want to come back, if I could, to a question that Senator Whitehouse asked you about qualified immunity. This is a judicial doctrine, among other things. Are you of the opinion that qualified immunity doctrine needs to be revised?
Senator, as a sitting judge, and if confirmed, I will continue to be a sitting judge at the appellate level, that is a matter for me to apply the law as it currently stands. It is revised by Congress or it's revised by the Supreme Court. I will apply whatever the law is.
It's not for you to revise, is what you're saying.
It is not for me to revise.
And you'll faithfully apply the precedent as it currently exists.
I will, sir.
Very good. Let me ask you a follow-up on what a question Senator Lee just asked you. I want to make sure I'm just crystal clear on this. He asked you whether the Supreme Court could admit new states. You started by saying you couldn't answer that question. I don't think that's your position. So let me just try again for the record. Can the Supreme Court of the United States, through its holdings or judgments, admit new states to the Union?
Senator, there is no precedent for that. So if I could answer that way, that's my answer.
Okay. There's no precedent for it, but is it permissible under the Constitution? I mean, this is a matter of, if it came to you as a matter of first impression, whether or not the judiciary could admit new states?
Well, if you read the Constitution, it's the Congress that admits the new states.
Okay, good. Let's come back to the question of how you would interpret a statute, how you would proceed in a case where you have no controlling precedent on point from the United States Supreme Court or from your own circuit, should you be confirmed. You have no controlling precedent on point. You've got to interpret a statute or a piece of the Constitution, again, where there's no controlling precedent. Walk me through how you would approach that. Let's take a statute. Let's just focus on that. How would you approach it? No controlling precedent. How do you move through the process?
Well, the first thing, Senator, that any judge will do when interpreting a statute, you look to its plain text. That would be step number one. Ideally, that will resolve the entire matter. If the text is clear, there's no issues, and you apply that statute to the facts of the case and resolve the case.
In the case when the text is ambiguous?
Where the text is ambiguous, you have to go to legislative history. And if that does not resolve the matter, you may not have precedent on that same particular statute, but you have to then look for analogous precedent. And let me give you one example. Title VII of the Civil Rights Act has been applied and interpreted by courts for many years. Years later, the Age Discrimination and Employment Act was enacted, and the precedent was that it should follow the same framework for ruling on the cases and applying the statute because they're similar. So you have to look perhaps to similar statutes, case law from my circuit, of course, but sometimes there's case law from other circuits. It's not binding precedent, but you have to look to see how everybody has been resolving the matter. And
so this, I think, gets us into the realm that Senator Lee was just talking about. What I don't hear you saying is that in the situation where the text is not plain on its face, where there isn't an obvious agreed upon meaning, what you didn't say is I would look to the original public meaning of the text at the time it was enacted. So in other words, I would look and see, well, when Congress or the state legislature or whatever, whoever enacted the statute, when they enacted it at the time, what was the public meaning? You didn't say that. So is that not something that you would consider?
Senator, if new statutes are enacted, it's the original public meaning also can be considered for the statute. And that is something that, for example, if Congress enacts a statute today or tomorrow, it is easier to follow those statutes and apply those statutes because the public meaning is usually going to be evident. And there's going to be statements also from the senators and the congressmen who enact that law.
But what if a lot of the statutes that you'll be called upon to apply, of course, and you know this, you've been on the bench, you do this every day, many of the statutes you'll be called upon to apply are decades old. And the legislative history, maybe it exists, maybe it doesn't, maybe it's ambiguous. So in the case in which you have a statute that you're trying to interpret, the plain text is disputed, and the litigants say, no, the plain text means this. Oh, no, the plain text means that. It's disputed. The statute is older. What do? How do you proceed? No precedent on point.
Well, Senator, original public meaning is one of the ways to interpret the statute, same with the Constitution. And again, I have to look at precedent, but that is also something I have to look at definitely.
So this gets at the question of your judicial philosophy, which is just another way of talking about your approach to statutory interpretation, to constitutional interpretation, to the role of the judge. I have to say I'm a little bit worried by what I'm hearing in response to Senator Lee and in response to the questions I'm asking you here. It doesn't seem to me that you actually would prioritize the text, its meaning. I don't hear any discussion about the methods for finding that meaning. There's a lot of talk about precedent. I understand that. But of course, if you're confirmed to this role, I think you're going to find yourself dealing with cases where you don't have as much precedent on point. You're going to have cases of first impression. And in those cases, the Supreme Court of the United States has clearly instructed that text is to be the first and primary consideration, and then ascertain the historical meaning of the text. I mean, there's lots of Supreme Court precedent on point. So I'll have some additional questions for you for the record to try and nail this down and make sure I really understand where you're coming from. Thank you, Mr. Chairman.
Thank you, Senator Hawley. Senator Kennedy is recognized for 5 minutes. Senator Hirono, do you wish to ask a second round of questions?
Oh, I'm sorry. I didn't know she'd had a first round. I apologize.
So I would like to make a comment after the Republicans go. So
Senator Hirono is
please.
recognized.
No, I think Senator Kennedy should go first because he hasn't.
I think it was my turn.
It is.
I thought you had yielded to Senator Hirono. Senator Kennedy, you're recognized for 5 minutes.
I didn't know that Senator Rono had a first
There you
round.
go.
No problem. Please proceed, Senator Kennedy.
Okay.
Thank you. There you go.
Judge, I'm still uncertain about your answer. Can the United States Supreme Court, on its own, admit a state to the Union?
Senator, as I answered, the Constitution of the United States.
This is a real simple question. Can the United States Supreme Court, on its own, admit a state to the Union?
I understand the answer is no.
Okay, thanks. Appreciate that. Do you think the federal judicial system is systemically racist?
Senator, I have had, as a sitting judge for 20 years, I have had cases that come before me involving allegations of racism. I have presided over those.
Yeah, but I'm asking about the federal judicial system. Is it systemically racist?
Well, Senator, judges apply the Constitution and laws, and we cannot, if you're asking about if judges are racist or the judicial system itself, we apply the laws, but we do not, a judge cannot take race into consideration.
Well, but do you think the federal, you know what systemic racism is? I mean, it comes up every day now in America, and do you believe that the federal judicial system is systemically racist?
Well, Senator.
You've been a part of it.
Yes, I can give you an example that the Congress and the Sentencing Commission.
I appreciate an example. I'm just trying to get an answer. Do you believe it's systemically racist?
Senator, that's a question I cannot answer.
You're a sitting federal judge right now?
I am a sitting federal judge.
How long have you been a federal judge?
20 years.
And you've heard these allegations that all our institutions are systemically racist, and after 20 years you haven't drawn an opinion?
Senator, I can tell you, in my court,
but you don't have an opinion about whether the federal judicial system is systemically racist after 20 years.
Senator, I have to say no.
You think it's not, or you don't have an opinion?
In my experience.
Wait, let me understand your answer. You think it's not systemically racist, or you don't have an opinion?
No, I don't have an opinion.
After 20 years?
That is correct.
And you want to be on the Court of Appeal?
Senator, yes.
Okay. All right, what's your definition of justice?
Justice, Senator, to me, means that the law is applied equally to all individuals, regardless of race, sex, position, and that all cases are heard by a fair and impartial judge, fair and impartial jury, and that the laws are applied equally.
Okay. How do we know what is your barometer for deciding whether a law that's being applied equally is just?
Well, as a judge, I have cases that come before me, individual cases. So
I'm not asking about a case. I'm asking about philosophy.
Well-
How do you just personally look at a law and determine whether that law, in your judgment, is just?
Well, it is not for a judge to determine whether a law
I'm not
is
asking
just or.
you as a judge. I'm asking you just as a person. I'm trying to understand you as a person.
Well, Senator, whatever understanding I have, if a law is just or not just, I have to apply that law.
Let me stipulate that, okay? Let me stipulate that. I'm not going to ask you how you rule on a case, and I know you're going to follow precedent, okay? You're always. I get that. How do you personally look at a law and decide whether it's just or not? It's pretty basic.
Well, Senator, that is not the role of a judge to determine if a law is.
No, but it's the role of a human being. I'm just trying to get to know you. Do you have a personal definition of justice?
Well, Senator, justice, in my particular case.
I know it's applied equally, but how do we know a law is just or unjust, in your opinion?
Well, Senator, as I mentioned, I have to apply the laws as they stand, and I have to make
Okay,
sure
let's
that
move on, Judge. I don't think you're going to answer it. Do you think, let me ask you about crime. You've sentenced people.
Yes, Senator.
Do you think crime is a disease that needs a cure? Or do you think it's antisocial behavior that deserves punishment?
Senator, as a judge, and I've been sentencing felony defendants for 15 years as a U.S. district judge, I've always followed the sentencing statute.
I'll stipulate that.
And I have to.
But I'm asking you about if a person commits a crime, do you see it as a disease that needs to be cured, or do you see it as antisocial behavior that merits punishment?
Senator, each individual defendant has to be sentenced individually. I have had individuals who are antisocial, and when you look at the pre-sentence reports, you sentence them accordingly. You have career offender, criminal. You have other individuals who have.
Judge, I can't vote for you if you won't answer my questions. I hate interrupting you, but these are pretty basic questions that I would expect somebody who's been on the federal bench for 20 years to have thought about.
The senator's time has expired, Judge. If you wish to respond, you have that opportunity.
Senator, as a judge, every time I sentence an individual, and I do this on an individual basis, I consider the nature of the offense, aggravating factors, mitigating factors, the person's individual personal history, his criminal record, and also consider the sentencing guidelines. And I apply that exercise on a case-by-case individual.
We both know that.